welfare reform, very much of which this House has passed, I think, 3 years in a row. In part, it is the time-limited grants which encourage recipients to seek gainful employment. If they're unable to do so, would require that they do 100 hours a month of county work program work. It also has a component which is commonly referred to as wedfare, which treats welfare recipients who leave for the purpose of getting married or for reuniting with their family the same way that it treats people who leave to go to work. It requires the Department of Social Services to provide us the necessary information to begin the process of regional grants for AFDC. In the area of AFDC eligibility, the bill would bar sponsored immigrants for 5 years from receiving state-supported benefits upon adoption of this policy by the federal government. Our counties will get some modest relief from this bill in that both the statewide automated welfare system and the AFDC fraud programs will go into effect. The bill will increase our contribution for these expenses and not ask counties for a single penny. To address the issue of fraud, the bill contains 2 new provisions. First, it increases the penalties for individuals committing fraud in the more extreme cases. And second, it expands the new hire file at the Employment Development Department to verify employment and potential income of AFDC recipients. On a positive note, the independent living centers which have helped our general fund condition by $1.8 million while simultaneously getting additional funding because of additional federal funds. So we're able to use that state money. And in turn, we made a commitment to maintain our support to them. The bill contains many provisions which would adversely affect people's life, but unfortunately the demands on us and the options we had were few. I have hoped to reduce the pain by taking further reductions in state administration, but we're unable to do that. This bill represents the negotiated compromise, and I ask for your aye vote.
Senator Watson on the amendments and on the bill.
Mr. President and members, this is an awful bill. This bill represents where public policy by the legislature has really failed. We have not been able to recognize the changing demographics of our state, and if we fail to look ahead to see what this state is going to look like in the year 2000, then we ought to go out of business and we all ought to resign. Here is a program that is the key part of the safety net, AFDC. And we think it's laudable to say we've only cut the grant by 2.3%. There's nothing laudable and commendable about that. We think it's really great of ourselves because we worked out a compromise. There's nothing laudable or commendable about that. We let people with the higher incomes take advantage of all the loopholes. And we say, well, let's just sock it to the people that continue to have babies to get the welfare grant. Well, if any of you would bother to look, with this percentage cut, it will be the first time the grant for a family of 3 has dropped below $600. What can you do with $600 and 3 people a month in terms of paying rent and taking care of the other necessities? Or I've heard people say, well, they have food stamps. Try to pay your rent with food stamps. I think it's shameful, and shame on us that we would allow the loopholes to exist and say, well, we just cut the bill by 2.3%. We also have the beginning of something that I think says bodes terrible things for the future, maximum family grant. That means if you're on AFDC and for some reason you have another child, you cannot have an increase in your grant to pay for the necessities that will be caused by having a new infant in your home, in your family. Those of you that preach family values, well, let's try to keep our families healthy and wholesome. by not taking the necessities away from children because a parent happens to have another child while on AFDC. I think it's shameful that we have forgotten what AFDC is all about. It's aid to families with dependent children. When we cut the grant, we're cutting the subsidy for children. When we don't increase the grant for new babies that are born, we then are hurting infants and children. We're going to be driving more women to have abortions if they're on AFDC, because if they have that baby, they're not going to be able to buy the diapers and pay the rent and do the other things that they must do. Most of them run out of their food stamps before the end of the month. You try buying food on food stamps. Now, I know you're sitting there saying, well, let them get jobs. I want to bring you, I'd love to give you a tour into South Central Los Angeles. For every job you bring me, I can line you 1,000 people up for that job. And if you think jobs are just waiting there in the city of Los Angeles for AFDC mothers, AFDC fathers, and AFDC families, then you need to get out of your districts and come and take a look for yourself. We know we need jobs, but we don't have them yet. And I would say to you members that we're setting a terrible trend in the state of California. The only reason why we exist is to build a safety net. Otherwise, we need to go home and let our salaries and per diem close the gaps and close the holes in that safety net. If we cannot protect children, we ought to not be here, and I'd urge a no vote.
Senator Marks.
May I ask the author of the bill a question? If required by federal law, does that mean the federal government must pass a bill? If required by federal law, sponsored immigrants shall be ineligible for AFDC, food stamps, supplemental security income, citizen supplemental program, SSI, SSP, Medi-Cal benefits for 5 years. What does that mean? Well, let me ask you another question. What do you mean a sponsored immigrant? Is that a legal immigrant? So you're saying that a person who is required, let me ask you another question. Is a person, if the federal government does not pass a law, will a sponsored immigrant be eligible for AFDC, food stamps, supplemental security, income state supplemental program, and Medi-Cal benefits? Will he be eligible? Answer all those questions.
Senator Peace.
Mr. President, members, in many ways, this trailer bill is probably the most important vote that we'll take with respect to the consideration of the budget this year, because it is, as Senator Watson pointed out, indicative of the fact that we really have not come to grips with the changing demographic in California, and that changing demographic with any context of whatever portion of the population that you may look at. This is what happens when you don't invest in your future. This is what happens when you don't recognize that any society, whether you go back to the ancient Greeks or to the emerging European civilization, the 16 and 1700s, or the great British Empire that ultimately collapsed of its own weight, that any society cannot survive if it is not a maker of things. We in California are setting a trend once again for the nation as a whole, and we've been out ahead on this notion of moving towards this information society, this great paper shuffler of the future. But the ultimate consequence is the erosion of jobs for the middle class. Senator Watson is right when she points out that you can't really reasonably expect a young mother with 2 children or 3 children to reasonably provide for her family on a $600 grant, or let's face it, on a $700 or $750 grant. And eating away at that base doesn't do anything to improve public policy or conduct or anything else, but we haven't given any alternative. We haven't invested in the real only legitimate safety net. That's assuring that in fact the opportunity for new jobs are there. Your constituents, Senator Watson, look at the alternatives. They look at the likelihood of success, and being fairly bright folk deduce that the odds aren't very good for them. And in many cases, they choose alternatives that none of us would hope that our young people would choose. My constituents do the same thing. And what we really have is an entire generation of Americans. They're my kids. They're many of your grandkids and some of your kids as well, who are looking at choices with respect to their future that are all out of whack. And they're out of whack because we look at bills like this and we talk about social services. This isn't about social services. It's about the failure of the entire job-producing segment of our society. It's about fewer jobs and lesser pay for the jobs that are there. Let's go beyond that welfare recipient, Senator Watson, and talk about the middle-class taxpayer with mom and dad both working, family still intact, making all the right choices. And mom works at Jack in the Box for minimum wage, and dad has 3 jobs probably, none of them making goods, all of them serving up services, and all of them not enough to support a family. And the bottom line is we can't continue to sustain these social services programs because we're not paying the working people enough to pay enough taxes to sustain the social services programs. So make no mistake about it. We can tinker until it all comes tumbling down with social services programs, but if we don't come to grips with the fact that we have allowed the incomes of Americans, of average Americans, of those who are out there working, to be decimated over the past 20 years. We have allowed them to be destroyed. We have taken away the capacity of the average 30 to 35-year-old young man and woman who's just trying to put a roof over their heads and feed their children. We've destroyed it. We've taken away from them. It's gone. They can't do it. You talk about demographics. Let me tell you a little about demographics. In 1960, that 35-year-old head of household, the one that did manage to stay together even under this economic pressure and social pressure and rising expectations, and has 2 kids at home, in that era, that dad went to work and mom stayed home and took care of the family. And dad was able to make enough money not only to put food on the table and a roof over his head, but to accumulate a little bit of wealth. Today, you take that same family, that same age group. Today, mom and dad are both working, again, in that segment of population where both mom and dad are still around. And do you know how much money they make relative to that 1960 family? They make 1/3. 1/3. The 2 of them working together make 1/3 of what the one-income household earner made in 1960. Do you know what their accumulated wealth is? It's less than 1/20th. 1/20th of what that same household was in 1960. And you think we're going to be able to solve this problem by extending tax brackets or looking at new elements of providing taxes or cutting this or cutting that? You can't solve this by cutting anything or raising taxes, anything. It's broken. Excuse me. It's broken. The system's broken. It doesn't work, and until we come to grips with the reality of rebuilding an infrastructure that produces real jobs with real wages and real benefits and real opportunities, our young people are going to continue to make second-class choices because we've only provided them with a second-class menu. So this bill before us today is about symptoms. We've got to pass it because we have to make the numbers work. But understand that when we embrace it, and as we will, and put it together, I would hope we would take back with us a sense of commitment to not find ourselves here again a year from now, and a recognition that the seriousness of the challenges that are before us as a generation in providing opportunities for our children go well beyond the little compartmentalized debate that we annually have on a budget.
Questions on the adoption of the amendments? Senator Thompson, you may close. You urge the adoption of the amendments? All in favor of the amendments, say aye. Those opposed, no. The ayes have it. The amendments adopted. Read the bill as amended.
Assembly Bill 836 by Assembly Members Goldsmith and Pringle, an act relating to human services, making an appropriation therefore and declaring the urgency thereof to take effect immediately.
Mr. President, members, again, please consider my remarks on the amendments to apply to the bill. In response to the questions or some of the issues that were answered, however, I would like to take just a moment. Senator Marks, your question in regard to the sponsored immigrants, yes, these are people who are sponsored and are here illegally, and in order to achieve the savings that's outlined in the analysis would require the passage of a federal law. And that, yes. Yes. On the issue of welfare reform, I want to point out that Senator Watson, that maximum family grant is not in this bill. That's going to be a separate standalone bill. However, there is some significant welfare reform in this measure. Time-limited grants, as I mentioned, the WEDFARE, and the language in here that is going to provide the foundation for moving to regionalized welfare grants, something that I believe is long overdue. It makes little sense to pay the same amount county by county on a statewide basis when it actually costs more to live in some counties than it does to live in others. And in regard to the decrease in the AFDC allotment, I agree with you, Senator Watson. It is sad that for the 5th year in a row we're going to again attempt to balance at least a portion of this budget on the AFDC programs, and that is in fact aid to family with dependent children. But I do want to point out that the governor's proposal was considerably different from what we negotiated that's found in this bill. Remember, he wanted to do a two-part reduction that amounted to, I think it was 25% reduction. We were able to hold the line. The grant reduction in this bill is 2.3%. And after 4 years of cuts, it's a tough one, but nonetheless, this is a negotiated amount, and I think it's the best we could do. I ask for an aye vote.
Further discussion or debate? Questions on the adoption of the urgency clause? Secretary, please call the roll.
Alquist. Aye. Ayala. Bergeson. Aye. Beverly. Aye. Boatright. Aye. Calderon. Aye. Campbell. Aye. Craven. Aye. Dills. Green. Aye. Hart. Aye. Hayden. No. Hill. Hughes. No. Hurt. Aye. Johannesson. Aye. Johnston. Aye. Kelly. Aye. Killay. Kopp. Aye. Leonard. Aye. Leslie. Aye. Lewis. Aye. Lockyer. Aye. Matty. Marks. No. McCorgadale. Mello. Aye. Peace. Aye. Petrus. No. Presley. Aye. Roberti. Aye. Rogers. Aye. Rosenthal. Russell. Aye. Thompson. Aye. Torres. Aye. Watson. No. Wright. Aye. Wyman. Wyman, aye.
Dill.
Matty, aye.
Dills, no.
Dills, no. Ayala, aye. Rosenthal, no.
All the members voted who care to vote. Ayes 30, no 7. The urgency clause is adopted. Senator Thompson requested that be deemed the roll call on final passage. Hearing no objection, ayes 30, no 7. The bill is passed. Senator Bergeson is requesting permission to turn to item 146 on file, local government trailer bill. Any objection? Read the bill, read the amendments.
Assembly Bill 860 by Assemblywoman Moore, an act relating to the Public Utilities Commission, making an appropriation therefore and declaring the urgency thereof to take effect immediately. Amendments at the desk by Senator Bergeson. Amendment number 1.
Thank you, Mr. President. Members of the Senate, the amendments to AB 860's Local Government Finance Trailer Bill. This bill makes the statutory changes that are already reflected in the budget numbers. Luckily, unlike past years, our state budget does not require us to shift property taxes from local governments to schools. This year, we're able to avoid that very unpleasant task. Instead, AB 860 modifies some of the prior year's property tax shifts. Some of these changes are wholly technical, some of them are significant. And although all of them are complicated, I would just like briefly to review them for you. The most important and the most expensive part of AB 860 is the correction to the ERAF, the Educational Review Augmentation Fund. Using a statutory ambiguity, some counties are taking property tax dollars that we earmarked for schools and have been spending them on redevelopment agencies. That practice has two effects. Number one, it saves money for the counties and cities, but number two, it costs the state general fund. AB 860 would stop that practice. Now, in deference to the County of Los Angeles, the bill allows county officials to phase in this correction over 2 fiscal years. This is not some draconian measure. In fact, it's a negotiated compromise between the Department of Finance and our state's largest county. Another item in AB 860 worth mentioning is a policy reversal regarding special districts. Late last year, we exempted some special districts' revenue from the property tax shift. This bill would make the adjustments of one-time funds, and then those mixed districts, special districts that provided for both enterprise and non-enterprise services would be excluded. Now, the final point to mention tonight are the new limits on local government's lawsuits. And that is against the state budget. For the last 2 years, the Attorney General's staff has heroically and successfully defended our trailer bills in a dozen-plus lawsuits that challenge the constitutionality of the property tax shifts. This bill sets a reasonable statute of limitations, 45 days, on any future cases and requires them to be filed and heard in Sacramento. These changes will save the AG a lot of time and money, and they will prevent needless litigation. This bill is a complex bill, but it is a very necessary measure, and I would ask for your aye vote on the amendments.
Senator Watson.
For a question to the author,
Senator Bergeson, yield.
Your amendments now change what was a PUC bill to local government finance?
Yes.
Okay, what happened to the PUC budget? Is it going to be something else?
No, I'm sorry, that is not in this budget. PUC, did you say?
Yeah, originally, wasn't this a PUC bill by Moore?
Well, this completely
Strips it and guts it.
excludes the former bill.
Yeah, would you know where they're going to deal with the PUC budget? I heard there were some changes in the Assembly.
No, I haven't a clue. Maybe some other member could answer that.
And you see, we're trying to follow with the amendments. Maybe the President Pro Tem can fill us in. We'd like to know what's happening with the PUC budget if this bill is being stripped of all of that and just deals with local government finances.
Perhaps we can help. I'm told by the Secretary that there is no PUC bill up for debate tonight. Senator Lockyer, on this issue?
Mr. President, in response to Senator Watson's question, in the budget that was voted on earlier tonight, it reflects the agreement on the PUC budget, which is a 5% reduction in their budget, but 95% funding. As you'll recall, the conference report that was passed earlier in the week had no funding. There was a 2-month bill that Assemblywoman Moore was carrying and a 1-year funding bill that Senator Alquist was carrying. Both of them were hoping to persuade the administration and the PUC to support a variety of reforms of various sorts in energy and consumer issues. Senator Alquist and I visited with the governor earlier in the week to urge his involvement in the reform discussion. I don't think we got any commitments that were firm other than to engage in a healthy discussion of those issues. So both Senator Alquist and Assemblywoman Moore have agreed to support the budget proposal that is a 95% funding level, which was before us earlier. So this bill is, there still are reform bills, a number of them, that Senator Rosenthal and Assemblywoman Bornstein and others are all pursuing.
Senator Hayden.
Good question of the author. On the issue of change of venue, I'm not entirely sure how tightly drawn the language is, but it seems to me that you might have concerns as chair of the local government committee on what happens to local government here if they sue the state of California. If I understand the shift that's contemplated here, simply if the Attorney General asks, this bill would require a trial court judge to move a case to Sacramento involving any lawsuit by local officials against state government. Is that broader than lawsuits involving the disposition of the budget?
Well,
Not that it would be justified in either case, but there are two paragraphs here. It says, the bill would require that the venue of any action or proceeding filed against the state of California in which a local agency is a plaintiff or petitioner be changed to the county of Sacramento upon the motion of the Attorney General. Then it says, this would require that the venue of any action or proceeding filed by a local agency against the state of California with respect to funding for that local agency be in the state of Sacramento. So there's two cases where the normal ability for the case to be set in the venue which is about to receive the impact is moved to Sacramento, where apparently there would be a more favorable venue. I don't think it's just to save the Attorney General money. I think there'd be a more favorable venue for state government against local government suits if the case was tried in Sacramento instead of in Los Angeles or San Diego or Orange County or wherever. Was this heard in committee? Is this I don't know when this amendment went in, but I think members who are concerned about the rights of local government to sue the state, especially when every year we keep slashing city and county budgets, ought to be concerned at the authority of the Attorney General to move a case to Sacramento upon whim. Upon whim. No appeal, no argument. He makes the motion, the case is moved out of your district back to Sacramento. Is that correct?
Well, I'm not certain that your assumption is correct according to the information that I've had, and that it is a cost saving, and that is the reason it's in this bill. No, it was not heard in local government, as many of these issues are not heard in committee, as you know.
No, I didn't know that. It's just a straightforward question.
I think to